Hello and very good afternoon to all of you. On behalf of ASSOCHAM, I'm Avinash Sharma, Director ASSOCHAM. I would like to welcome all of you at this webinar on Drawdown to 2021 with discussion on key income tax issues, which is being organized by ASSOCHAM in association with SW India. SW India is a member firm of SW International and is present in 10 cities across India. It has a strong leadership of 16 practice leaders with 300 plus professional staff base. They operate in multiple practice areas dealing with assurance and advisory, direct tax, international tax, indirect tax, merger and acquisitions, management consulting, and outsourcing. Today, they are associated with us for this webinar in which they will discuss the selected case laws on direct and international tax, which were decided by the Indian courts in 2021, followed by a panel discussion consisting of eminent experts from industry and SW India. The speaker for case law discussion is Mr. Saurav Sood, who is a practice leader at SW India's International Tax and Transfer Pricing Vertical. He is a chartered accountant and lawyer by qualification and is having more than 14 years of experience in the field of international tax and transfer pricing. He is an active member on international tax issues and has spoken on various forums in the past. With these words, I would like to invite Mr. Saurav Sood to take the things forward in the session. Over to you, Mr. Sood.
Thank you, Avinash, for the introduction to the firm and about me. From this point onwards, I'll just take it forward. Good afternoon, everyone, and welcome to the session. Thank you so much for taking time out and joining us. Today, we will be taking few selected cases of India tax jurisprudence, which has been delivered by various courts in 2021, which will be followed by a panel discussion consisting of the industry experts and senior partner from SW India. We endeavor to complete this session 10 minutes before the scheduled time so that we are able to dedicate some time to the question and answers, which you as participants will be having after the discussion. You can all post your questions to the chat box or to the quick Q&A box, and the able team members will be able to take it up here and on. Before now beginning with the case law sessions, the first one which I'm going to, so the case laws we have taken from international tax and as well as the domestic tax. To start with, I'll be taking the case dealing with the withholding tax obligations on payments towards purchase of computer software, which has been a burning issue for the past decade and which was very recently settled by Supreme Court in the judgment of March, followed by a judgment of ITAT Bangalore in the case of Quest Software and IBM Singapore. Now, taking this session forward, so the sale of license for use of software has always been a point of contention. For the past 10 years, we have been seeing this litigation at various stages. There has been ITAT judgments, there have been judgments of the High Court, there has been judgment of a Supreme Court in the case of G, where different interpretations have been made to this payments, where some decisions favored in withholding of taxes on such payments made to non-residents. Some decisions had a different interpretation. On 2nd of March, the Supreme Court settled this long-pending issue with its case in the case of engineering excellence, where this issue was decided in the favor of the taxpayer. After that, as we know that the suo motu benefit will not apply, the tax officers will have their own interpretation, which has to be countered with the judgment with the facts of each case. So therefore, there are two recent judgments which have been passed by the ITAT in Bangalore in the case of IBM Singapore and Quest Software International. The facts of the cases are very similar to the facts that were presented before the Supreme Court in various litigation cases. In this, the Singapore-based company was dealing in the software and hardware products, which were sold to the software to its associated enterprises or distributors in India for subsequent sale to the end customers. The license to use software that was given to the end customer and the payments that were made by the distributor for purchase of software was something a point of contention that on which the tax authorities had a view that the withholding of taxes has to be done. In this case, the treaty under contention is India and Singapore. Now, basis that the provisions of law that we read, how this judgment actually affects and how this judgment has been delivered by taking the cognizance of the Supreme Court judgment, we just discussed over that. The provisions of section 195 deals with sum chargeable to tax. It is different from the other withholding tax provisions of the Income Tax Act, where the term used is any sums. Therefore, the distinction is that it is only when the sums are chargeable to tax the trigger of 195 happens. Where, now, for the purposes of determination of a sum chargeable to tax, what we have to see is, are those chargeable to tax in the under the provisions of the Act read with the benefit, if at all given under the provision of TT, which is available to the taxpayer. Now, when we read the definition of royalty, which is provided under explanation to section 916, the understanding that we develop is the definition is wide enough to cover any types of payments towards the software or a copyright in a software which is covered over there. Now, basis this definition, definitely we can see that there is a case for the tax authorities to ask for a withholding of taxes. But where in case these payments are made subsequently to a non-resident, the treaty provisions come into picture. When the treaty provisions are seen, we have to see how the royalty as a term has been defined under Article 12 or 13 as the case may be. Now, when we read the treaty provisions, UN Model Convention and OECD Model Convention are two prevalent model commentaries basis which the definitions can be interpreted. In case of India, Singapore, the definition of royalty is pretty akin to the OECD commentary, which was also the point for decision in case of Supreme Court judgment. When we read the OECD model of commentary, there the royalty is defined under a restrictive meaning. When we say restrictive, the definition does not cover all or any rights. It is a very specific to say that only when there is a copyright which is being transferred in under such circumstances, the payments are subject to TDS or the payments are subject to tax under the treaty. Now, referring to the end user license agreements, when we read the end user license agreements, we have to understand that end user license agreements have to be read harmoniously, have to be read interpretively and purposefully. The end user license agreements in case of software payments never provide any copyright in the product, never provide any copyright to the end user or to the distributor. It is only the copyright, it is only the rights in a copyrighted article which is provided for the purposes of use. That is, you can download and you can use it, but you cannot make a copies out of it or you cannot duplicate it. Now, when these restrictive rights are interpreted and read, can we say that the definition as provided under section 14 of the Copyright Act read with section 30 satisfies to it could be called as a payment towards a license to use? The answer is, this is a payment which the answer that Supreme Court held is the end user license agreement are restrictive in nature. They have to be read only for the purposes of stopping the end user to create a duplicate copies out of it. It do not provide any copy to alter the software, do not provide any right to duplicate the software. Therefore, basis that the Supreme Court held in the favor, saying that Article 12 of the OECD commentary or the specific tax treaty read with the provisions of Income Tax Act giving the benefit under section 90, the such sums which are made for the purchase of a copyrighted article are not subject to royalty, therefore not subject to TDS in that case. The same interpretation was applied in this case, where the ITAT also held that non-transfer of right to use the product or limited right of installation with no right to reproduce the same will not make it as a payment of royalty. Lack of use or right to use any copyright, coupled with the fact that it's a mere sale of a product with limited rights provided through end user license agreement, does not make it a royalty under the provisions of India-Singapore Treaty. Hence, in this also the ITAT held in favor of the taxpayer, and it was subsequently held that there will be no withholding of taxes on the payments to be made. Now, just to add further to it, the Supreme Court, while delivering its judgment, also acknowledged the fact that explanation added to the definition of royalty from 2012 definitely makes it the definition more exhaustive. But even that, still the benefit under the treaty being a restrictive definition of royalty, therein the benefit will apply, and therefore there will be no sums which will be chargeable to tax subject to withholding tax in case of a payments of license to use a software. Moving away from the judgment of royalty, I'll start with the next judgment, which deals with Abu Dhabi Investment Authority of India. It's a advanced ruling judgment delivered by the Authority for Advanced Ruling, which was challenged by a taxpayer before the Bombay High Court. The facts in this case are very, very peculiar. So I thought I'll take up this case. It deals with a foreign trust. It deals with the settler, which is outside India. The trust is in country X, the settler is in country Y, the benefits of which treaty shall apply. Now, in this, the investments, the issue that came before the High Court was that investments made by a foreign revocable trust, which of which the settler is, of which the beneficiary is based out of Jersey, will the be taxable in India in the absence of India-Jersey Treaty? Before I move to the conclusions and the positions, I'll just narrate the facts of the case. In this, Abu Dhabi Investment Authority made certain investments in debt portfolio in India. For making this investment, it incorporated a trust vehicle in Jersey. That trust vehicle subsequently made investments in India. Now, when the interest or the income that accrued to that trust, the income tax authorities had a viewpoint that Section 5 read with Section 9 will apply in this case, and due to lack of treaty between India and Jersey, it will be governed by the domestic tax provisions, hence taxable in India. The counter to this to it by the taxpayer was that the settler of the trust is Abu Dhabi Investment Authority, which is a UAE tax resident. It is also the sole beneficiary of the trust. The trustees are only for the purposes of managing the trust. Hence, the provisions of India-Jersey Treaty will not be the comparative of India-Jersey Treaty will not be the case over here. It has to be India-UAE Treaty, under which Article 24 specifically exempts income from state authority. Hence, it should not be taxable in India. The department's view to this was that since in this case the income accrues to the trust in Jersey, therefore the India-UAE treaty is not applicable. It is a foreign trust. It will not be governed by the provisions of the Domestic Tax Act, that is Indian Income Tax Act. Therefore, Section 61 to 63, 160 in this case will not apply. Hence, it will be taxable under section by reading Section 5 and 9 only, and in the absence of treaty, taxable in India. To this contention, the case was decided against the taxpayer, and subsequently the taxpayer preferred a writ before the Bombay High Court, and the Bombay High Court went into the facts and circumstances of the case. The Bombay High Court was of the view that provisions of Indian Income Tax Act do not restrict itself only to the foreign trust. There is no compulsion under the Indian Income Tax Act that the foreign trust, if not registered in India, will not be governed by the domestic tax provisions. There is no compulsion under the income tax provisions that makes it mandatory for the settler to not to be a sole beneficiary. The Indian Trust Act also do not restrict a settler to be a beneficiary. Since the beneficiary and the settler in this case is a UAE tax resident, and the trustees are only for the purposes of managing the trust. Therefore, the income will be taxable in the hands of the beneficiary, which are UAE tax residents, and therefore the Treaty of India and UAE shall apply, and Article 24 benefits shall be given to the taxpayer in this case. Now, basis this, what we understand is that in case of a trust taxation of a foreign trust, where there is a foreign settler as well as there is a foreign trustee, the beneficiary's tax resident will be a determinative status for the purposes of understanding the taxation in that case. That is how the taxation has to be governed with, and that is how the taxation was actually rendered in this case by the Bombay High Court. And therefore, the absence of a foreign trust registered in India will not be a contention which was acceptable. It is not a precondition. The Indian Income Tax Act provision shall still apply, and basis that the judgment was held in the favor of the taxpayer. So moving on from this case to the subsequent case, this is the case which I think I'd like to spend some time, because there has been a recent Delhi High Court judgment as recent as day before yesterday, which is a 106-page order in which the contentions of the taxpayer against a reopening of the assessment has been held in the favor of the SSC, where the notices of 148 has been quashed, which were issued under the erstwhile provisions of the Act under the extended timelines. Now, we are aware that there are total 3 judgments of different high courts in the favor of the taxpayer. Then there is one judgment of Chhattisgarh High Court which is against the taxpayer. So though this BPIP infra deals with the Rajasthan High Court judgment, which is last week's judgment, but I have also tried to sum up the arguments and the contentions and the position that is held in case of Ashok Kumar Agarwal, which was the Allahabad High Court judgment. Since in both the cases, the basis of deciding the case in the favor of the SSC has been same, therefore it can be read sacrosanct for both the cases. Delhi High Court judgment, I had a chance to have a cursory look, not an in-depth look, but my basis of that cursory look allows me to say the arguments were similar, the contentions were similar, and it is the same basis on which the judgment has been held in the favor of the SSC and the notices have been quashed. Now, what exactly was the issue which came up before the different high courts? What was the issue that was raised by the taxpayers against the income tax authorities? Finance Act 2021, through its enactment, I think on 28th of March 21, amended certain provisions of reassessment, under which section 147, 148, 149 were amended. A new section 148 capital A was introduced. By this new section, there are certain additional uh, responsibilities and guidelines which have been entrusted on the tax authorities to satisfy with before an assessment can be reopened. Earlier, it was the reasons to believe that were to be satisfied by the tax authorities in itself, basis which a closed assessment can be reopened for the purposes of reassessment. But under 148 capital A, now the inquiry has to be done by the tax officer. The result of the inquiry has to be communicated to the SSC, and SSC has to be given an opportunity of being heard. After this procedure has been undertaken, only then an assessment can be reopened. Now, this makes it more onerous and more responsible on the tax officer to satisfy. Therefore, the reopening becomes more subjective rather than being more objective in the erstwhile provisions. Now, while these amendments were carried on, the date of implementation of the new provisions started from 1st April 2021. That means from 1st April onwards, the new provisions of 148 capital H was introduced, and they will be applicable for any reassessment to be undertaken. While these new provisions were enacted, while these new provisions received the blessings of the parliament as well as the assent of the president, due to COVID in March 2020, March 30th, 2020, certain relaxations were proposed through a relaxation bill, which was subsequently passed in, I think, 29th of September, basis which the government was empowered to issue certain notifications for extending the timelines of compliance, both for the SSC as well as for the tax authorities, be it assessment, be it refund processing, etc. Now, after this notification, there was a notification of 31st March 2021, followed by a notification of 29th of April 2021, basis which the reassessment notices, which were otherwise time barred on 31st March 2021, due to either monetary limit or due to the time barred provisions, they were given an extended timeline to be timelines, basis which the tax officers issued notices till 30th June 2021 for the assessment years which were otherwise not allowed to be issued because of the time bar nature. Now, after these notices were issued, these were issued in the old provisions of the Act, which in fact were superseded by the new provisions of 148 capital A read with after the Finance Act amendment. Now, since these provisions standard superseded, there was no saving clause under the Income Tax Act for the old provisions. Now, basis this, many notices which were issued in the erstwhile provision after the timeline had expired, the SSCs raised the contention before the High Court. In Delhi, what I understand is there were more than 1,300 writ petitions that were filed, and these 1,300 writ petitions has similar prayer that notices which have been issued under the old provisions of reassessment should be quashed, because once the new provisions have kicked in the absence of a saving clause, these notices are time barred and these notices cannot be issued. Now, the case went before the High Court. Elaborate, detailed hearings were undertaken both by the taxpayers' councils and as well as by the department. After this, the judgment was pronounced. What this judgment says, the judgment, if I have to, so basis this background, the judgment says that the High Court held that in the absence of a saving clause in the Act, wherein the old provisions have been superseded or substituted by the new provisions, the notifications which have been issued under the Relaxation Act cannot save the provision, cannot extend the timeline of the old provisions once the new provision kicks in. Once a new provision kicks in, the steps that have been enshrined under the new provisions have to be followed by the income tax authorities. The old provisions becomes obsolete. They will not be applied for the purposes of issuing the reassessment notices. The notifications that have extended these timelines are delegated legislations and therefore cannot supersede an act which has been given the blessings of the parliament as well as the president. In absence of that blessing that have of the parliament, the Finance Act 2021 supersedes the old provisions, and therefore the reassessments from 1st April 2021 onwards have to be undertaken under the new provisions of reassessment, and their basis that the cases have to be reopened. To which now this after this the notices which have been issued in the old provision stands quashed. The department will not be able to proceed further on these issues, and therefore the relief has been granted to the SSC. Now, after this, the question that comes, I'm just extending this further because this is not something which is a part of the judgment, but since many queries we are receiving from our clients, so I just thought let me just put it across that this is our understanding, of course, that those SSCs, those who have not participated in these proceedings by way of filing a writ petition, will this benefit be suo motu applicable to them, or they have to file an application before the High Court? To our understanding, what we understand is that if you are falling under the jurisdictional High Court's judgment, the assessing officer has to comply with that judgment. The notices that have been issued, because this is a judgment which is not interpreting the provision of the law of how the taxes have to be withheld, or how the taxes have to be charged. This is on the validity of the notice. The validity of the notice, once held invalid, stands applicable even to the assessees, those who are not a participation, those who are not participated in the court proceedings, and an application to the assessing officer stating this judgment should take care of it. However, where in case the assessing officer still proceeds with the reassessment under the old provision, then of course the higher forums have to be approached for the purposes of making those notices invalid. This is our understanding. It may be subject to different interpretation, but this is how we are able to read the provision and we are able to guide the clients. Of course, these are yet to be tested, but as and when it comes to the part of testing, we'll be happy to share any views. Moving forward from the judgment of the decision that deals with the reassessment, I'll just move to the next judgment. This is the case of Concentric Services Netherlands. I think nobody in the International Tax Forum is precluded from this judgment. So this was a judgment which was issued, I think, in April 2021, in which the High Court of Delhi interpreted the provisions of India-Netherlands Treaty, MFN clause, which is available under the protocol to the treaty, and the benefit, whether that benefit which is given by the MFN clause is applicable or not. Now, what the issue of contention was that the dividends which were otherwise subject to withholding tax at 10% under India-Netherlands Treaty, through the applicability of the MFN clause, which is enshrined under the protocol to the treaty, gives that beneficial rate of 5% if any member of the OECD country has such beneficial rate in its treaty with India. Now, the protocol does not go further to say whether the treaty with such other OECD member has to be on the date when the India-Netherlands Treaty was entered, on the date when when it was the member of the OECD country, or it has to be on the date when such benefit is being availed by the taxpayer. Therefore, the tax authorities had a view that where, in case of India-Netherlands Treaty, the benefit comes through the Treaty of Slovenia or Lithuania, which became the members of OECD subsequently. That is in 2000, at the time when they entered the treaty with India, they were not the members of OECD, though there was a beneficial rate of 5%. Subsequently, in 2012, they became the member of OECD, and the rate of 5% was still applicable. Since they were not the members of OECD at the time of entering into the double taxation treaty with India, hence the benefit of 5% will not be available in this case to the taxpayer under India-Netherlands treaty read with the MFN clause, to which the taxpayer had a different interpretation. The taxpayers were of the view that it is on the date when the benefit has to be taken. The status of the membership to OECD has to be seen, and the rate of tax, if beneficial, will be applicable suo motu. Now, department had raised a couple of contentions before the High Court. One contention, of course, was the date on which the member has that state has to be a member of the OECD. Second was that protocol of India-Netherlands Treaty is not suo motu available. In the absence of a notification to the protocol, the benefit under the protocol for the MFN clause is not applicable. To which, while these contentions were raised, the counter contentions were presented by taxpayer. The Delhi High Court held, so it quoted its earlier judgment of in case of India, in case of Styria, where a similar issue came about the interpretation of protocol. In that case, it was India-France treaty, where the benefit was for the purposes of fee for technical services through India-UK treaty, which has a restricted scope, that is make available. And there also the Delhi High Court held that protocol is suo motu available. Once a protocol is entered and signed, it becomes the part of the treaty. There is no separate notification that is required, and it has to be read as an added text to the treaty. While holding a senior judgment, Article 31 of VCLT, Vienna Convention on Law of Treaty, was also discussed. Under Article 31 of Vienna Convention of Law of Treaties, the interpretation that has to be given to a phrase or to a clause in a treaty, and the text that is added to the treaty subsequently, or a amendment that is done to the treaty, how it has to be read. The understanding that the court gave was that once a protocol is added to the treaty, it becomes a part of the treaty. It has to be read alongside with the treaty. There is no separate notification that is required to make a protocol effective. The treaty, the amended text, or any clause or any additional text to the treaty has to be given a plain reading. Once the sovereign states have agreed to an amendment or to an added text, it becomes part and parcel and has to be read alongside. There is no separate enforcement that is required for such protocol. Now, basis that the protocol debate was settled, it was held held on the understanding what the taxpayer also had. The benefit of MFN shall be available. Now, the second question that came is that while in case of India-Netherlands Treaty, the benefit of MFN is coming through Slovenia Treaty, while Slovenia was not the member of OECD at the time of entering into the treaty, whether the benefit will still apply or not. To this also, the court held in the favor of the taxpayer. The court held that it is on the date when the benefit is being taken. The date, the relevance has to be seen from an OECD perspective, whether you are a member of OECD or not, net on and not on the date when the treaty was entered into. Since in 2021, Slovenia is the member of OECD country, the benefit is to be availed by the taxpayer. Therefore, in that case, the benefit of 5% beneficial rate of withholding tax shall also be available in case of an India-Netherlands treaty, and the case was held in favor of the taxpayer. Now, this brings an end to our case law discussion. We'll just move from case law discussion to the panel discussion after this. While moving to the panel discussion, we have curated two different topics which we will be taking care in the panel discussion. One topic deals with the MFN clause, how it has to be read, how the benefit has to be ceded to the taxpayer, how the and the second deals with the GAR versus SAR, which is an evergreen topic, though we haven't seen much of a GAR litigation as on today, but definitely there are a lot of SAR litigations which are going on under the India tax jurisprudence. So as and when the GAR litigation starts, how do you read those provisions in a harmonious manner? Moving to the panel, I'll just give a small introduction to the panel before I start. Before that, may I request the panelists to please switch on their camera so that I can give before I start the introduction of the panelist. Anithan.
Hi everyone.
Atul.
Yeah, hi everyone.
Yeah. So moving on to the panel discussion, I have with me Mr. Atul Puri. Atul Puri is a co-founder and practice leader at Shinewing India. He is engaged in providing tax advisory services to firms' largest global clients. He's a chartered accountant of having more than 20 years of experience in corporate tax, business advisory, having a versatile experience in his domain. He has assisted many clients in their tax and business structuring for corporate setting up their business in India for multiple geographies, including US, France, UK, Australia, Singapore, Korea, Japan, and China. Atul is accompanied by Mr. Nitin Jain. Nitin Jain is a head of global tax and treasury at OYO. He has a considerable experience in business advisory, transfer pricing advisory, cross-border transactions, business structuring, and tax optimization. He's an active speaker in various forums and is a part of senior management team in growth and expansion of OYO. Then the third panelist is Mr. Kinjesh Thakur. Kinjesh is in India head of international tax, expatriate tax, and transfer pricing at Linde Energy Engineering. In his academic career, he has secured All India rank 19 in Chartered Accountancy and All India rank 4 in Company Secretarial course. Prior to Linde Energy Engineering, he was associated with Deloitte. He is recognized by various technical forums for putting his thoughts on paper and providing a perspective to tax law. He has written various articles published in various journals, magazines, newspapers, and online portals. He has also taken presentations and guest lectures at various professional forums and universities on international taxation. A very warm welcome to all the panelists, and thank you so much for participating with us. Before
Thank you,
I move to the
Saurav.
Thank you,
Saurav, for the introduction.
So moving on to the panel discussion, we have two topics. That is the most favorite nation clause, which for which I just digested a case before we switch to the panel discussion, and the GAR versus SAR debate. Moving on to the most favored nation clause, I think the first question that comes to me, which I want to put across to the panelists, is Atul, to specifically to you, I'll start with you first. So
Are we
what are
using
your
this PPT?
thoughts?
Mr. Sood, are you using this PPT?
No, I think I can close the GPT.
Yeah.
Can you just stop sharing it,
Just
or it has to be done on my end?
a second. It's still showing, I think. You need to close this sharing option. It is at the top. So once you click on this screen, there's the top side. There's an option of sharing or
I think
stop
you'll have to
sharing.
then give me that right. I am right now. I think I'm not even presenting right.
Just a second.
So I make it as a whiteboard.
You can just stop sharing if you need to stop sharing. Thereafter, I think.
No, I think I'm not getting an option of a stop sharing.
Okay.
No, I'm not getting the option of stop sharing.
Not if you can just continue the panel discussion. In that case.
Okay.
So you can continue with the panel discussion.
Yeah, I'll just do that. Yeah. Thank you. So, Atul, I'll just put this question across to you. So the Concentric case of Delhi High Court, in which the most favor nation clause was discussed and interpreted in the favor of the taxpayer. What are your thoughts on the Delhi High Court judgment in the case of Concentric Services Netherlands, dealing with the issue of interpretation of MFN clause?
Yeah. So first of all, the objective of MFN clause is that the state who has signed any bilateral trade agreement with the other contracting state is not prejudiced or disadvantaged when more liberal terms are agreed by the other contracting state with a third party. So, in this case, the issue before the Honorable High Court was to adjudicate and summarized in the two broad categories. Primarily, if I divide this into two issues, which was addressed in this case, issue number one was related to protocol to a tax treaty is applicable suo motu or needs a separate notification. And issue number two is related to the MFN application and its relevant date. So MFN clause was to be read for India and third states that were OECD members when tax treaty was signed between India and Netherlands, or third states that were members of OECD when the treaty between them and India was signed containing such beneficial provision, or third states that entered into treaty but became members of OECD subsequently. So the two questions which were addressed in this classic case, which I would like to put some highlights. So in the case of issue number one, the court, while holding it in favor of the taxpayer, held the MFN clause in the tax treaty has limited application. The MFN clause can come into force only after some affirmative action is taken by the two contracting states after the other contracting states' tax treaty with the third state granting a more beneficial tax treatment is either entered into force or becomes effective. So, uh, what I mean to say is that, in other words, the MFN clause present in tax treaty being conditional does not come into force automatically, and the satisfaction of the agreed conditions are a must between the two contracting states to operationalize the MFN. It also restricts the scope of a particular article or provides for reduced rate of tax. It is a byproduct of bilateral negotiation between two sovereign states. Also, the existence of MFN clause in the protocol will not make it less than any article of tax treaty. Now, having said that, protocol is to be read together with the tax treaty and is an aid to interpretation of the tax treaty clauses. The MFN clause is placed either in the main body of the convention or in the protocol itself. In majority of the tax treaties, MFN clause is incorporated through a protocol. So in this context, there has been a lot of litigation and controversy in Indian jurisprudence as to whether protocol is merely to be used as an interpretive aid or whether it forms an integral part of the treaty. So on this, Dr. Klaus Vogel in his commentary mentions that legally they are part of the treaty and their binding force is equal to that of principle of treaty text. When applying a tax treaty, Therefore, it is necessary to carefully examine these additional documents. There is no requirement of a separate notification for a protocol to tax a treaty or to apply it. Also, in the judgment of Sharia India Limited, uh, which was relied by the Honorable High Court in the case of Concentric, wherein the assessee contended that having regard to clause 7 of the protocol, the less restrictive definition of the expression fee for technical services appearing in the Indo-UK DTAA must be read as forming part of the India-France DTAA as well. So in this case, the AAR, in the case of Sharia India, the AAR disagreed with the assessee. It ruled that the protocol could not be treated as forming part of the DTAA itself. Further, it also held that make available clause found in the India-UK DTAA could not be read into the expression FTS occurring in the India-French DTAA unless there was a notification issued by the government to incorporate the less restrictive provision of the India-UK DTAA into the Indo-French DTAA. So, in the case of Sharia India Limited, where in the similar issue came before the Honorable High Court in relation to India-France DTAA on the restrictive scope of FTS clause basis India-UK DTAA, to which the Honorable Court held that protocol signed between India and France separately form an integral part of treaty itself. And once DTAA has itself been notified and contains protocol, so there is no need for protocol itself to be separately notified. So that brings a rest to my issue number 1 with respect to the protocol and its application. In regard to my issue number 2, in context of the MFN clause, the two dates which are most relevant here are the cutoff date for selection of tax treaties with third countries for triggering the MFN clause. In line with provisions of the MFN clause, only tax treaties entered on or post the cutoff date as stipulated are to be compared for purposes of invoking the MFN clause. So the date from which the MFN clause will become effective or operational, this date could be the date on which the tax treaty with the third state come into force or become effective. In this regard, the court held that the third country should be the member of OECD. I repeat, the court held that third country should be the member of OECD at the time when benefit is availed by the taxpayer, and not necessarily when the tax treaty was entered into with India. Second, India should have, in its convention executed with the third state, limited its rate of withholding tax on subject remittances at a lower rate or a scope more restricted than the rate or scope provided in the subject convention. So once once aforementioned conditions are fulfilled, then from the date on which the convention between India and the third state comes into force, the same rate of withholding tax or scope as provided in the convention executed between India and the third state would necessarily have to apply to the subject DTAA. So that brings in and addresses the issue number 2 with respect to the date. Over to you, Saurabh.
Now, yeah, thank you so much, Atul, for this. Just a follow-up question to what Atul has concluded. Nitin, I'll just put it across to you. So when we say that the third state has to be a member of the OECD for the purposes of availing the beneficial rate on the date when the taxpayer is taking the benefit, do you think this interpretation that has been given by the court aligns with the international tax laws, or is there anything different that the international tax law says which may be the case? Because the last ball will always be in the department's court. What googly they were going to give it to it at the subsequent stage of as a litigation.
A good one, Saurabh. So let me try to answer this question in a three parts. The first part is that what we really see and what we really mean by a tax treaty. Okay, I think I need not to really elaborate on that, but then just for the sake of repeating here, it's not per se a law. It's a instrument. It's a negotiated instrument between the two governments, which is further approved or ratified by the parliament of a country, depending upon which country we are referring to. But it's not a law which is made by the lawmaker or approved by the parliament. So that's a fundamental difference between a tax treaty versus a versus the law. The second is that what is the Indian jurisprudence around that? And I would like to sort of take a bit of references here from the Concentric judgment itself, which is really and very beautifully touched upon this aspect. So they have said that look, the treaties are negotiated and entered at a political level, okay, and have several considerations as their basis. They have given a reference to many international authors when they said that what is the function of a double tax treaty, and it has to be seen as aiding the commercial relationship between the two treaty partners, between the two countries, and it's a bargain what is being driven by the two countries. So it's essentially what it means is that these are the treaties conventions which are negotiated by the diplomats and not by the men which is instructed in the law. So that's the second point which even the concentric judgment has referred in a very detailed judgment by the Delhi High Court. Beyond that, from an interpretation point of view, if we go back, what the Supreme Court has said from an interpretation, from a literal interpretation also. So in the case of, I just refer that the case of a Hindustan bulk carrier, they said that the construction which reduces the statute to a fatality has to be avoided. A statute or any enacting provision must be construed to make it effective and operative on a principle expressed therein. So which essentially means that what was the intent, what they wanted to carry when the tax treaty was negotiated and agreed between the two partners. Okay. Now, the third aspect of this is the Vienna Convention, which we have been referring here and what the court has also referred. Now, India per se, we have been, and the Vienna Convention has been used many times in a various judgments. But then interestingly, India is not a signatory to the Vienna Convention. Talking about even the ratifying is a very different context. It's not even a signatory, but still, the various courts, the various high courts, even the Supreme Court has drawn a lot of reference to the interpretation when it comes to the Vienna Principles. And if we go back to the Article 31 of the Vienna interpretation rules, now what does it say? It says that it should be interpreted. The treaty should be interpreted in a good faith, and the meaning to the terms should be given in an ordinary sense. It is not something what should be interpreted, what the legislature or what the lawyers look for that. The other reason and the other thing what they have said in the Vienna Convention is that apart from the treaty itself, any agreement or instruments which has been signed later on or which has been agreed between the two partners at a different points of time, even after the treaty has been signed, that also forms part of the agreement and has to be understood. I think this is where even the court has taken a reference or have quoted that if India has not pointed out, has not given any circular on that, but then the Kingdom of Netherlands, they have this is the to the Dutch entities. So this is how the treaty gets interpreted. So I think that's where the rules of the interpretation rules of the construction comes in, and I believe it is as per the international law, and which is what has been upheld by the Delhi High Court in the concentric judgment.
Thank you, Nitin. I think what I can hear from Atul and you is you are in total sync with the High Court's judgment. But and definitely that is the way the judgment has been written. It is a beautifully explained judgment where the points have been settled while holding it in favor of the SSC. I think, Kinjesh, I'll just put a question to you on this judgment itself. Somewhere in the judgment, if my memory corrects me rightly, the court mentioned about the decree of 2012, in which the Dutch domestic tax law, after the amendment in Slovenia's position as an OECD member, passed on a mention about the beneficial weight. Do you think that apart from VCLT, what Nitin just elaborated and how the MFN has to be treated vis-a-vis a protocol, this was also one of the factors that came into picture while deciding it in the favor of the taxpayer?
Yeah, thanks, Sauru. This is really an interesting question. So this is all about looking into the interpretation from other partner as well. And what you are saying is right. There has been a decree. Now let me start by going through the series of events that have happened. in this entire. So the first one was in 2005, there was a treaty entered in between India and Slovenia. So that was coming into force. Then it was 2010 when Slovenia became member of OECD. That is 5 years later after the treaty has entered into force. Around 1.5 years later, that is, it was somewhere in maybe end of 2010 they became member, and in 2012, nearly initial part of it, there was a decree which came from Netherlands, which specified that as per their interpretation, as Slovenia is now member, the benefit of MFN clause should be given in India-Netherlands treaty, adopting the third state, which is Slovenia, now that becoming the member of OECD. Delhi High Court has also dealt with this decree, that is also provided in the judgment. What was the decree? And Delhi High Court has also referred to the principle of common interpretation, which is recognized in the international tax law, that any treaty should be interpreted in same way by both the parties. Even if I refer to Dr. Klaus Vogel, they have also said that any interpretation which should be given to treaties should be such that it is most likely accepted by both the parties. So going back to again what Nitin said in the answer, this is a treaty, this is a tax treaty. There are two political states negotiating it, so it's a bilateral thing, and therefore all the principles and commentary will always focus on having a common interpretation to a particular issue. Now when there is a decree which is there available, Netherlands has already interpreted it, and therefore Delhi High Court, if gives a judgment which is not in consensus with it, it will not follow those principles of having a common interpretation. And therefore it has been one of the reasons, not the sole reason to be very honest, but yes, this has been one of the reasons to give this judgment in favor of the taxpayer using the decree of Netherlands, which was in 2012. And probably to a great extent I agree with judgment, but there is only one thing probably I would also like to bring out, and maybe it's a food for thought for many people here, that can this decree, when they have dealt with, there is no comment on whether that interpretation is right from the perspective of court.
True.
So this is something where I say whether it is adoption of an interpretation or evaluation and then interpreting. So my friend saying me a view and I accepting it immediately without evaluating. And the second, just a layman's example, he saying me a view and I interpreting whether it's correct or not and then accepting it. So it's rather a common interpretation or adoption of a unilateral interpretation. For the purpose of common interpretation. So I mean that's the food for thought, and probably this debate is something I don't think is going to settle here.
No, definitely. So I think just to summarize, so Atul agrees that Atul, just correct me if I'm wrong in terms of understanding your point of view, that MFN through a protocol need no separate notification. It becomes a part of the treaty. The benefit in the MFN it automatically is given to the taxpayer. Nitin, VCLT comes to the aid for interpretation. You have to give a purposive interpretation, the interpretation which has to be acceptable from the perspective of the contract signed between two sovereign nations. From Kinjay's perspective, I understand that the decree of 2012 gives a purposive interpretation. That interpretation has to be commonly understood by both the parties. Therefore, summing it up from three speakers' perspective, the judgment is reasoned. The judgment is in favor of taxpayer. However, Kinjesh has a point of discount to say that whether it has been adopted or whether it has been persuasively used, something which we will see the light of the day as and when the judgment stands challenged. Now,
Yeah.
having said that, I'm
Just
sorry.
to add, I think, yeah,
Yes.
just to add here, I think not a very direct reference, but then I think Azadi Bachao Andolan has been a great landmark in our jurisprudence. But even if you read the the Azadi Bachao judgment, uh, the time and again the stress by the Supreme Court has been that you had to look at the interpretation or the purpose when it was made, whether it was the legislature or whether it is a tax treaty out here. So for what reason it has been made out for, and this is how it has to be understood at that point of time. So it's not a time when it is relevant when you are interpreting. It has to be looked at when it was negotiated and agreed for, and that's the purpose of the tax treaty is all about. But just I thought to add what you have just
Right.
summarized.
Fair. Point again. So I think once we have this, now since we have two eminent speakers from the industry and we have a senior person from the consulting, I think it will be interesting to understand when it comes to issuing a certificate of 15 CACV. Atul, I think I'll first pose it to you. I want to see how adventurous we can be. When it comes to issuing a certificate of 15 CACV, will you be guiding the client to take the interpretation of this, the benefit of MFN on a as it is basis? Or will you be giving some sort of caveats ki, boss, I will not sign it so easily. Thank you so much. I need to understand it first.
So Atul, before you answer, so there are two clients sitting on the panel.
No, I agree to that. And having said and having deliberated this case law, which has brought a paradigm shift in the thought process, uh, both from the industry and the consulting side, how I would actually how I would actually interpret this, or I would advise my clients. Basically, in this scenario, there are two situations which can happen probably, where my client comes and tells me that we have to make a foreign payment, and my first question will be whether to adopt the outcome of this particular case law, whether the payment has to be made to a group company or the payment has to go to a third party service provider. And in case it's a group company to whom the payment has to be made, then as was the situation in the case of Concentrics, the process of lower or nil withholding tax certificate can be followed. I'm saying again saying it can be followed, as the time is not an essence for making payment. As we know, the procedure takes its own sweet time, and with the group company, we have the client can literally have the liberty to delay the payment till the time the authorities verify and validate the documents and give us the lower withholding tax certificate, so that benefit can be availed in case of a group company. However, where the similar payment has to be made to a third party vendor, such obligation can be to the recipient of sums of money to obtain such certificate. Else, what happens is that unambiguous position should be applied. That is, non-granting of suo motu benefit of MFN or such similar clauses. Also, where the payment is to be made to third-party vendors and there exists a clause of grossing up. In that case, such additional cost can be avoided by taking this position of availing a suo motu benefit of MFN clause. Though it is a High Court judgment subject to further challenges, which obviously is the route available to the authorities, but a call can be taken basis the nature of transaction, the nature of the recipient, whether it's a group company or you can say a third party vendor. So I think that's what my advice would be: how to analyze the transaction when it comes to adoption of this particular outcome of the case law. I would still, I would still like to understand from my co-panelists and my friends from who are part and parcel of the industry, what is their take on this and what is their view, whether they are also in alignment with what our thought process as consultants is, or they have a different view or divergent view on this. Nitin, may I request you to first share your thoughts, please?
Sure, Atul. Atul, I partly agree with you what you have just said. The fact that where you can really control the payout, then and more specifically when it is between the group companies, you will always have an option to go to the tax authorities and ask for a specific ruling and play safe with that. But the other flip side of that is because if these payouts are a part of a contractual arrangement, and if I talk about Concentric, the fact that you have declared a dividend, you will have to make a payment of the dividend, and accordingly, you have to do a withholding of a tax. Now, if you are not doing that, And if you have done that and if you're not depositing, then you always should be considering the consequences of the interest and the other relevant part of that, because the 197 or 195 certificate is going to take time before you lay your hands onto it. So that's another important factor you should keep in mind. Maybe you can plan to apply in advance, but then and the fact that now the government has got an e-governance mechanism. You've got a citizen charter. You've got a rights here wherein you can expect those issues getting resolved within a time defined manner. But still, given the deposit timelines are pretty stringent timelines, so you don't have the option to delay on those. And then otherwise, we know the kind of prosecution notices all of our industry friends would have got if they have not deposited the taxes out there, right? So that's one part of the story. The other part is, as you said, that if the contracts are grossed up or the payouts has to be made net of tax, and then in any way it's my cost as a company. And if it's my cost, so I sort of do it now, or I leave it at the time of my assessment when I may choose to have it litigated at that point of time. I think this is where, in the fact also that, as you said, that there's a high court ruling, and not just one, but there are other precedences are available in the case of Australia also. So very much, I believe our fellow friends in a practice should be able to give us the certificates to allow the payments to be made out there. One part I will prefer here, if the contracts are sort of a net of tax contracts wherein you can do a withholding and you can sort of make a payment after deducting tax. Still, you can sort of agree with the business, because at the end it will have an business relationships with the other party here, and here the business comes first. The other party may not like you guys doing the withholding, even if you have a contract which allows you to do a withholding. Maybe as a and that's a suggestion. So maybe as an alternate, and if this becomes more of a problem or of having a negotiation with your vendors, you can agree for a mechanism of indemnity, wherein in case at any later point of time there's an issue comes up, and you're sure that your vendors and your partners are your long-term partners, and they will be more than happy to pick up those costs at a later point of time. So that could be the another mechanism when you can do a remittance without doing a withholding, and then back on your indemnification arrangement out there. I think these are more of a practical solutions rather than more of the legal solutions here.
Right. I think Kinjesh, we will be happy to have your point also.
Yeah. So basically, I think if I have to evaluate, probably I agree with Atul and Nitin in a part, but I think 4 or 5 factors will play a very important role in it. First of all, I will also look at the country for which we are adopting this MFN. First of all, if it's a clean thing, it's nothing like what we are discussing right now, it becomes a simpler case. But if it is something which we are discussing right now, then if I go back to the facts of Concentrics, there is one phrase which has not been evaluated, which says that this beneficial provision should be available in the MFN clause as from the date when the treaty has entered into force. So when I look at India-Slovenia treaty that has entered into force in 2005, whereas it became OECD member in 2010. So basically, if I adopt a view that I should start the benefit from 2010, then that phrase becomes redundant to a great extent, which is not evaluated, which may be evaluated in future. So that is something which phrase is included in India-Netherlands treaty. If you look at different treaties like India-Sweden, that phrase is not present. So it depends on the treaty, the type of the text in the treaty, based on which one can take a judgment, and that whether this is too bad. So if it's a India-Netherlands kind of a treaty, probably I would prefer to go with a lower withholding tax certificate, because there is still some things to be resolved. But if it's the India-Sweden treaty or it's a very clean case, probably MFN can be taken. The second factor which I will look at, which is also very important, is timing, which I think Atul and Nitin touched upon. So if the timing is quite a factor in it, then one has to take a call that whether to go with lower withholding or not, and this will play an important role along with a factor called quantum. So if the quantum is high and the time is low, then one has to surely take a call. One cannot go with lower withholding tax certificate. and then that call has to be in line with what penal consequences are. So it's a based on risk benefit analysis. Cannot be said right now, but it will surely be something which a consciously some has to take a call, including an opinion from a consultant that what they believe, just to uh, protect the company. Other part is again gross up, and gross up, if they are bearing, if the company is bearing the taxes, then probably it's something a call can be taken along with lower withholding should be asked. But if they are bearing their taxes, then a factor called foreign tax rate comes into picture. If they are getting the credit, then there is no need to take a view which is aggressive. So that can be again negotiated. So it will depend on 4 or 5 factors, and everything will play an important role, from country, quantum, timing, I would say, of the factor of gross up along with foreign tax credit. And then this call of lower withholding should be applied or not. So there is no clean answer from my side at least, but I would say that this 4 or 5 factors needs to be evaluated, and everything would have a weightage at that particular point in time.
Right. I think to sum up, we'll say that our aggressiveness and the dynamism the tax authorities we have in India doesn't allow us to take the benefit of a high court judgment also. We are still always cautious about any steps we take further because we know there are going to be doors which can be breached any day to reach to us. So having said that, so where I can hear the words of indemnity, the timing, the gross up, the amount, the time, the opinions, I think it's time to move to the next topic, which deals with the judgments of a tax avoidance versus the judgments of a tax optimization. So when I say tax avoidance and tax optimization, they are often words which are used in different spheres. The taxpayer prefers to use as optimization, where the judiciary, where the authorities say it as a avoidance. Now, to understand this avoidance and optimization, the authorities have moved a step further to introduce GAR as a provision. That is the General Anti-Avoidance Rules. Now, once the GAR has come into picture, every optimization will be seen from an avoidance angle, and every avoidance angle will be subject to GAR, of course, threshold limits keeping aside. Though we as taxpayers, you as taxpayers, we as consultants were already dealing with the uh, justifying ourselves for the SAR provisions, there's something more generic which has come to us. And though we haven't seen much of a judiciary getting active for it, but as in today, it's a matter of time here and there when the GAR will be more prevalent. And of course, SAR we always have seen is an active source of jurisprudence in India. Moving to GAR and SAR, we know that GAR has a mechanism which has to be adopted for it to be activated. There are certain parameters which are there which has to be satisfied. There are certain conditions which needs to be satisfied, after which a GAR can be applied, a transaction can be recharacterized. So, it is different in case of SAR. SAR are the provisions which are very specific, which are enshrined in the act. There is no separate code to it. It is a part and parcel of the provisions of the act, wherein transfer pricing is one of the codes which can be applied. Disallowances of excessive payments to a related party are the codes which can be applied, and so on and so forth. So just to set the context, Atul, I'll take the liberty to ask you first. So when we say GAR and SAR, so I'll say it is a test to the specific versus general. Where a taxpayer satisfies the specific, that is taxpayer satisfies the SAR provisions, will it still need to satisfy the GAR provisions? What are your thoughts to it?
Yeah, so I think it's a very valid question, Saurabh, and this has been uh, one of the critical questions which we have been asked in the past by a couple of our clients also, where there can be scenarios where whether the if the SAR has been specifically satisfied, then whether the general provisions or the GAR will also have the overriding role or not. So although this might not should not be taken as a standard interpretation, but still it's my own personal view that there can be multiple scenarios that can exist, uh, such as, so I would divide them in 3 scenarios. So domestic GAR versus treaty SAR. Second is GAR versus SAR, both under domestic law. And third, GAR versus SAR, both exist judicially. So, in all purposes, both are forms of anti-avoidance rules and are to prevent the misuse of tax provisions. So, the concept of general over specific, wherein specific overrules general, shall prevail. However, where a same transaction is to be analyzed from GAR and SAR perspective, and SAR has limited application, then in such case, GAR can apply to address the situation in entirety. This has further been supported by Circular 7 of 2017 that presence of SAR may not address all situations. Thus, GAR and SAR can coexist and apply in parallel. I would say, it is internationally accepted that specific anti-avoidance provisions may not address all situations of abuse, and there is need for general anti-abuse provisions in domestic legislation. Therefore, the provisions of GAR and SAR can coexist and are applicable as may be necessary, basis the facts and circumstances of the case. So it's very subjective, and it is we would need to analyze from a case-to-case basis, or from each scenario. It will bring its own nuances before any single view or single opinion can be applied to it.
Right. I think um, moving on from the subjectiveness to the specifics, Kinjesh, I'll put it across to you. So while we understand the SAR provisions exist in the treaty, which is, do you also think that the Domestic Tax Act also has similar provisions to take care of? Do SAR also exist in Domestic Tax Act?
Yeah, so I think SAR exists, I think, in every sphere. If you say international tax as well as domestic tax, if I just give you a few examples, then in international taxpayers, you can see the provisions like beneficial ownership, limitation of benefit clause. Then recently what MLI has brought in is like uh, changes to the PE definition with respect to creation, that is a dependent agent playing a principal role rather than habitually concluding. Even playing a principal role can make it a P. Anti-fragmentation rules, wherein different activities getting split up and classified as auxiliary activities, but on a comprehensive manner they form a P. Then these rules are also now in picture, which are specifically addressing these issues. There is also splitting up rule, wherein certain times contracts were split up just to avoid the P. These specific rules are also there from a treaty perspective. These are now there. BPS action plans were all part of SAR. These are all specifically addressing most of the specific abuses that have been identified in the international tax space. You can even see the companies, the shares of the company which has an underlying value derived from immovable property is something again a part of SAR. This is all existing in international tax space. Even I think what BPS is further acting on 2.0 is again from SAR. If I go to the domestic legislation, what are the SAR provisions? One of them is, and I think everyone knows it, it's transfer pricing. They are protecting the base for the country, and that is one of the things. It creates an adjustment which is a primary adjustment, and over and above that, another SAR provision in domestic legislation is secondary adjustment. This specifically provides for adjusting when an excess repatriation has happened to an associate enterprise, or there is a primary adjustment. That money needs to be brought back to India. If not, then pay additional one-time taxes, or maybe pay taxes on the interest, deemed interest. So this is how that is also acting. There is another SAR provision in the domestic legislation which I call thin capitalization. That is limitation on interest deduction to the extent of 30% of EBITDA. So this is also there in the Indian Income Tax Act, and one of the very famous provisions, indirect transfer. This is also there present in the Indian Income Tax Act. So I think comprehensively, if you will look at, it is present everywhere. There are SAR provisions. As and when people identify a new provision or a new technique to save certain taxes, there is something which will plug the loophole in the form of SAR. And if not, now we also have GAR, which is the topic for discussion today.
I think, Kinjesh, I'll just say that you have given us enough cautions to be aware of. So we never thought about it as a SAR. We always thought about it to overcome it in terms of a tax audit report also. But nevertheless, I think thank you so much for that. Moving on from the SAR provisions, I think Nitin, this is to you. So while the taxpayer is able to satisfy the SAR provision in terms of their applicability, in terms of their conditions, and it somehow reaches the provisions of Section 90, subsection 2, which gives the taxpayer an option to avail the beneficial treaty provisions if they are applicable to it. Do you think that while the taxpayer through Section 90 subsection 2 reaches the treaty, GAR, through Section 90 2 capital A will be able to pull it back to say that you are still doing a tax avoidance, so come back to the Income Tax Act, pay your taxes, thank you so much?
So it's like probably getting played between Saurabh Ganguly and Virat Kohli. See, interesting one, but then there are no wrong or right answers to this, Saurabh. So let me just a bit step back here and look at what exactly Section 90 and 92 refers to and what really GAR talks about just for a minute. So 92 gives an option to the taxpayer to see that what is beneficial to him in terms of the tax treaty versus the local provision, and as per his choice then he can exercise his right to get governed by the domestic law or by the tax treaty. So that's what 92 talks about. Now that was somehow not full, but then in a bit way has been overridden by 92A, which is that irrespective of that, and it starts with a non-obstant, which is 92A, that even if you have a benefit or you don't have a beneficial, you can still have an application of a GAR to a non-resident person. Now, what does it really mean? It means that the government intent has been to really apply the GAR even if you have the intended benefits available to you in the erstwhile, I say those benefits covered under the tax treaty. Now look at the current scenario where we already having the MLI coming into here. We are talking about BAPS, and within the MLI we are talking about the principal purpose test also. So it's going to be a really interplay between the tax duty also. Are we really getting satisfied by the principal purpose test? Are we really looking at the GAR in a very strict way, or it is within a GAR also we are referring that it is the whole of the arrangement, or it is going to be a part of the arrangement which is not meeting the requirement under the Indian tax laws out there. So what I will say here is that it's not something which is going to be really plain vanilla. It has to be seen really on the facts of the case. But then when this 92A came in, or when the GAR was brought in, the government didn't had thought about the MLI at that point of time, right? So
True.
the MLI and all the BEPS negotiations came much later after that. So that's something which still needs to get tested. But then yes, coming back to your question, looking at the plain language of the law, the government still have the right to overrule. But then that has to be seen in the current context of the PPT under the tax duties and under the MLIs out there. But again, as I said, it's in the GAR, so it could be like if there are multiple steps into it, so one steps may get nullified because of the 92A, but then you may still get the advantages of the part of the other steps in the overall commercial arrangement which you might be referring out here. But again, this will go by a very case-to-case specific, so you can't frame out very generic answers to this question.
I think that one step benefit versus the entire structure is something which yeah, I think that is something which just caught my mind. Thanks for that input. I'll just discuss with you after this. So coming to that point, I'll just put it across to both the industry speakers this time. I'll take them as I'll take this liberty of being the moderator over here. So now I'll say I satisfy the SAR provisions, Kinjesh. I satisfy the test of residence under article within. I am eligible for a benefit through section 90 subsection 2. I go to the treaty. Treaty is a CTA, cover tax agreement. Through the that means both the countries have adopted the MLI provisions. Now it's a cover tax agreement. The moment you are a CTA, there is a preamble which undergoes change. I do not have the purpose of availing only the treaty benefit. I satisfy that also. So that means after satisfying these three boxes, I am able to sail through MLI also. Can the authority still say that the GAR provisions will apply to me, where they say that, Nitin, I'm just taking a cue from your last answer, that
Yep.
you may satisfy the structure, but there is a step in between, which is an abusive step. I will have to disignore that step. I will not give you the benefit for that specific step, though the overall structure may have a different connotation altogether. This is both to congestion, Nitin.
So you, Kanjesh, you want to take up before I give my views on that?
Basically, see, in this entire view, first of all, I would like to say that Article 1 of the OECD commentary specifically says that, I mean, if I understand your question correctly, let me first take the understanding. You would like to say that whether GAR can stop the arrangement if I certify all the provisions of the treaty. That is what the question is, right?
Yes.
So OECD Article 1 commentary provides and says that the GAR provisions, that is the local legislation anti-abuse provisions, can still apply to the transaction, the international transaction. And they also say that why it applies. The reason is that Income Tax Act, that is Indian Income Tax Act or any other country's Income Tax Act, is a domestic legislation. Treaty cannot create a liability of tax. Treaty cannot levy tax. Treaty is a tool to divide the taxes between source country and residence country. It's more of a tool to divide the taxes which is already present. So the taxes are levied by a domestic legislation. When there is an abuse of tax, then tax treaty is not only abused, the local legislation is also abused, because that is the legislation levying taxes. Treaty is only dividing the taxes. So that is where they say that even the domestic legislation, if it's trying to stop the abuse, the GAR will come into picture. So and GAR has got a specific term which is called impermissible avoidance arrangement. So arrangement is something they look at. They do not look at something which is, I would say, specific to any transaction. And let me give you one simple example for it. Let's say there is a subsidiary company and there is a holding company. Holding company needs money, and subsidiary company has to give that money to holding company. If they give it normally, they will get the interest income, which is taxable as per the treaty. So they find a person, which is a financial institution in a third country, deposit monies. The subsidiary deposits money in financial institution, and financial institution gives loan to holding company. Now, if this transaction is there is no tax at all because of treaty interplays. And therefore, I would say PPT can come into picture, and it will say that if one of the main purposes as per the PPT rule is to get tax benefit using the abuse or abusing the provision something, then this will be denied. The treaty benefits will be denied. So one do not get treaty benefits. But how GAR will come into picture? Here, if you see, the entire arrangement is granting a loan by subsidiary to holding company, wherein we have a local provision which is called deemed dividend. So here, if GAR is not present, you will just deny treaty benefits. But when GAR is present, this arrangement, and GAR has got the powers to disregard, recharacterize, and maybe do anything with that arrangement so that it brings out the substance of that arrangement rather than the form. And therefore, it gives a very wide power to the tax authorities to recharacterize this. And if we see in nutshell, there's an accommodating party, it will be disregarded, and there is a loan transaction directly happening, will fall in the category of deemed dividend, which if only PPT would have been applied, would not have been the case. If SAR would only have been applied, would not be the case. So GAR and PPT, I think everything will play an important role, and in my view, everything needs to be satisfied for the moment.
Nitin, your views on this?
Yeah,
Anything?
so just I think just to add, so Kandish has very beautifully articulated that. So I just add more into it. So I don't think there's nothing else left out there. But then see, look at the what does MLE requires? MLE requires that if one of the purpose of a transaction or an arrangement is to obtain a tax benefit, okay, then it fails the principal purpose test. And when it is not satisfied, then the benefit of the tax duty will be denied. Okay. Whereas if you look at the GAR is invoked if the main purpose of the arrangement is to avoid tax. So in a way, what that really means is that PPT is a more of a stricter threshold for a substance as compared to the GAR, right? So if while the benefit of the GAR can be given or cannot be given, it will depend upon if the main purpose of the arrangement is to avoid tax. Whereas PPT would be attracted if one of the main purpose of an arrangement or transaction is to obtain benefit. And this is where the example what Kinjesh has given. So it's going to be an interplay. It's going to be a very fine interplay between the GAR and the tax duties interpretations coming with the MLIs out here.
So I think what I understand is that you may satisfy one of the main purposes, but where your one of the purposes is satisfied, but main purpose is not satisfied, still the GAR can come to the rescue of the tax authorities. So they have drafted it in such a way that it is subjective, it is wide enough to tackle any kind of situations. Now I think what only that can save a taxpayer is that they should try to not breach the threshold limits. The GAR will not automatically trigger, but if the threshold limits are breached, then ultimately the GAR will have to be satisfied. And we are off late seeing transactions, we are off late seeing queries where the taxpayers are very sensitive towards the GAR also. They always want us to see whether they will be satisfying the GAR provisions or not, because someday down the line, if the structure gets negated as such, the whole purpose of spending that time and effort on that structure becomes zero value, and the funds or the HOs prefer to come in a more better and efficient way instead of spending time in creating those structures here and there. So I think just to conclude,
just to add. So I think time and again, sort of the way the current tax regime has been going on worldwide, not just in India. I think, and every time and again, the tax authorities has always put a stress upon that what is the need for any structure or a transaction, whether it is really satisfying so-called your business rationales or a commercial substance. If that is what becomes the fundamental for any transactions or whatever you do out there, then I believe the job of the taxpayer as well as the advisors are going to be pretty easy. Versus if something is going to be created which is not becoming a natural process in an organization. So I just take an example here. So if you are just creating an intermediate holding structure or you're layering an entity in between just to take a benefit of a tax duty and you don't have a people here. Now at the end what will happen? You will end up having all the discussions, all the paper trail, all the documentation in a natural course of action coming back to the parent entity and nothing to do with the holding of the intermediary holding company. But whereas if you put the people, if you put the right set of structure itself in that intermediary company wherein they are the one doing it, which in the natural course of action will happen, then nobody will really question your structure. So it's gonna come down all about your business rationale or a commercial substance. Anything which is gonna get created, I'm sort of very heavily relying on the words getting created. Anything which is gonna get that way, it is really going to get questioned, be it under the GAR or be it under the tax duties out here.
I think just to add to what you were saying is all these additional compliances of master file CBC are also the ones which are speaking about themselves. About the structure as a whole, where an entity is bound to disclose many things now which otherwise were not required to be disclosed, has to automatically comply with a lot of substance form in the jurisdictions where they are present. So going forward, all these reporting mechanisms are going to be trigger points of various queries that we will be receiving of it from the income tax department, where they will be questioning the transactions, where they will be questioning the intermediate jurisdictions and the purpose for it.
And I
So
think
just to add, Saurabh, to what what Nitin just mentioned, and bring some more clarity to it. Basically, for any structure which has been designed to get it classified as an impermissible avoidance agreement, and to understand what are the intentions, whether they are aggressive intentions behind it. It is the entire legality of GAR puts the onus on the assessee itself to prove that it does not qualify as an impermissible avoidance agreement. So while designing the structures, it is very important to understand that there should not be any such kind of aggressive positions which ultimately end up into any kind of profit shifting or benefits which are being routed out from the Indian tax jurisdictions.
Right.
And Saurav, to just add to Nitin's point, even I think not only those arrangements which are created, I think even the genuine arrangements, these can also be subject to scrutiny under GAR, and there's a requirement that everyone should keep all the required contemporaneous documentation just to prove that this is a genuine arrangement. I think that no one from prima facie point of view could identify whether this is created or it's genuine. Sometimes it could be very in between. It's neither black, neither white. It's totally gray. No one can identify. Here, the documentation will play a huge role. And probably what Nitin said about intermediary holding structure, I think these things may also change in future with Pillar 2 coming in picture, which is saying that there is a global minimum tax proposal already in plan. The restructuring time has come for many of the corporates.
True.
Right. And job for us
Right.
and the advisors.
Yeah.
Right. Yeah. Just checking. Yep.
Right. I think thank you so much, Nitin, and thank you so much, Kinjesh, for your insights, for your practical experiences, the issues that you have brought forward. And Atul, thank you so much for sharing your experiences while dealing with multiple issues at hand. Thanks a lot to all the panelists, and thank you to all the participants for being with us and being a part of our discussions and debates. Thanks a lot to everybody. And
Yeah.
thank you, ASSOCHAM, for hosting us.
Thank you
Yeah,
everyone
thank
for
you
the
very much,
session.
sir, for sharing your important views with all of us. And with this, now we come to the close of this session, and we would like to thank all the audience for attending this session, and we will share the presentation shared by Mr. Sood with all of you. Thank you very much. Thanks so much.
Thanks a lot.
Thank you,
you.
everyone.
Thank
Thank
you
you,
very much.
ASSOCHAM. Thank you, everyone. Bye-bye.